Good morning, everybody. Let's initiate a new journey with the lecture series. See, as we discussed yesterday, that law is the most prominent subject if one failed to bring a transformation in the society with the help of this tool. But how to enforce it, how to implement it, how to understand it, that is a very challenging task. It requires hell amount of efforts in terms of time, energy, money, understanding. For 5 years, 3 to 5 years, like you learn in academically, then you join some senior, you try to understand the nitty-gritty of law, you get the practical exposure also. Even then you don't feel confident to take a matter independently or argue the case independently, because it requires hell amount of courage, skill, wisdom and in-depth understanding. So this understanding you need not to be fair, because you will be developing this understanding over a period of time. It is not that in one day you will dream of becoming something and you will turn out to be hero and people will start clapping for you. It is not likely to happen that way. Fine. So everything takes time and everything you need to start from the scratch only. See, criminal law we would be discussing from today onward. The subject which I feel that everybody should be conversant with, that is procedural law, CrPC, Code of Criminal Procedure. It is for two reasons. If law we can classify into two things, like substantive law and your procedural law. Now substantive law, we all know that it prescribe the rights and the duties. Fine. For example, if offense of theft has been committed, now you need to see that what is the ingredients of the theft and what is the prescribed punishment for the theft provided under the act. So you can memorize the definition, you can understand the ingredients also. Fine. If it is not done with the dishonest intention, the first and the foremost requirement of establishing somebody's guilt of theft, then dishonest intention is required to be established. So it has to be there. Then it should be with regard to the movable property only. It can't be with the immovable property. It can't happen to the immovable property. Fine. That is the second ingredient. And the third one is that you have taken away from the possession of somebody, even if he is not an owner, he is possessor merely, and you took away. Fine. Then the offense of theft would be said to be committed, complete. Fine. So if you know the ingredients of the offense, then you will come to know that yes, he falls within the definition of this offense. Now that person has been charged with the theft. Now he has to be tried. Now you are a judge. You are to establish his guilt. The aid is going to be provided by the public prosecutor to you in the court of law, because whatever evidence has been collected by the investigation agency, that would come with the prosecutor, public prosecutor. He will bring it before you. See, sir, this is what we have examined. We have collected this much evidence against him. Now you have to decide. Now everybody is bound by law, even if he is a judge or a public prosecutor or any stakeholder, litigant or the defense counsel, everybody is bound with the law. Now whatever decision we have to render within the conformity of law only. We cannot surpass. Therefore, this procedure and a mechanism has been provided to us, which we have to obey, which we have to follow. We cannot surpass it. Each and every stakeholder is bound with the provisions of CrPC. So it is the procedure which is to be followed. Now, another third important subject is Indian Evidence Act. Now, court is sitting, presiding over, fine, in a one room. It does not know as to what has happened outside. Fine. Court cannot walk away and check or examine or inspect. Although section, there is one provision 210 wherein court can go to inspect the things, but still court is not going to go there, So all the evidence or the witnesses, whosoever are coming forward to the court for the examination, they are the ears and eyes of the court. Fine. You are a judge. Ears and eyes are before you. Either they have seen the occurrence, they have heard the occurrence, they have perceived something, now they are bringing it before you. Fine. Now all those witnesses are again cross-examined by the defense counsel, because the role of defense counsel is to defend the accused. He will try to prove the innocence and the prosecution will try to prove the guilt of the accused. Now the evidence of both, the evidence are before you as a judge. Now you have to decide. Fine. You have to weigh the evidence. Fine. So if the prosecution proves the case beyond reasonable doubt, then you will hold the person guilty, accused guilty. Fine. If it fails, then you will give the acquittal. Fine. So the thing is that now from the practical aspect, practical angle, we will try to understand as to how does it practically happen, what are the important stages, what are the important norms and provision which you must know in order to do the complete justice. Your job is gonna be very pious, fine, very sacred, job you are going to perform, because somebody's life is in your hand, somebody's future is in your hand, fine. So his life should not be put into peril unnecessarily where it is unwarranted. This is what you have to take care of, fine. So therefore, we really want that judges should be very, very competent, very vigilant, and they should have a thorough knowledge about the subjects, fine. Now you are to take in your notice, like, what are the important development, evolvement taking place. If you're not aware, then any advocate would come and play with you, any smart and shrewd advocate. So your job is going to be very important, fine. So these are few general things which you have to keep in mind. I have told you the importance of the CRPC, IPC only, IPC and other substantive law. It is not the CRPC is meant for IPC only. Other substantive, if we say that POCSO Act recently passed 2012, a lot of cases now, I think in state of Maharashtra only, if you will analyze, you will find 40 to 50% cases pertaining to POCSO Act only. It has emerged so much of importance because earlier there was no law pertaining to the protection of children. Exclusive law was not there, fine. So the moment it came into existence, the cases started getting highlighted, and the number of cases are, in numerous, fine. So it is again a very alarming stage for India, a nation like us, fine, which is overpopulated, wherein a lot of crimes are happening, but the crime pertaining to the children or the sexual assault are on an alarming note, fine. So drastic, stringent provisions, drastic steps are required to be taken. This is the need of the hour today, right? So let's come back. So CRPC provides the mechanism not only to aid the judiciary, the court, the investigation agency, every stakeholder, fine. The court has to strike a balance between two interests. One, individual interest is there. Second is the societal interest is there. Now, individual interest is what? If my life and liberty is being curtailed, or I am being subjected to unwanted, uncalled for litigation, fine, or for which I am not supposed to, then court has to see it, whether the justice is going to be happen with this fellow or he is unnecessarily being victimized. So wherever my interests are required to be protected, court has to use this tool effectively, fine. So here, but society on the other hand wants that he is a wrongdoer. He has committed some flaw which was not acceptable, which was actually, see, in law, what do we do? First you understand it. Certain norms, certain behavior, certain conduct, which is not anticipated from us, we commit. The moment we commit, it hurts somebody's sentiments. It causes pain to somebody. It injures somebody's interest. The moment it injures somebody's interest, he feels aggrieved. Then he lodges a complaint against us, or he lodges an FIR against us. Sir, he's a wrongdoer. He has done this thing, he should be punished in accordance with law. This is what the law is, fine. So the norms we have decided ourselves. The behavior which we do not expect from us or from anybody else, we want it should be governed, it should be monitored, it should be regulated through law only. Then what do? We choose our representative by casting our valuable vote. We send them in the parliament. Sir, please make a law for us. We need it, our society need it, and we want that we should be governed by law. Are you getting it? Fine. Now, we want that we should be governed by law. Now, they deliberate on the different subjects. Say, law pertaining to tax है, excise है, custom है, criminal law है, beneficial legislation है, like labor laws है, civil laws हैं, Transport of Property Act है, Hindu law, Muslim law, their personal relationship, marriage, adoption, guardianship, these kind of things, we deliberate. And we deliberate, and then we come out with the kind of law we are going to discuss today, that is CRPC, fine. So law is not an outcome of one day. It requires hell amount of deliberation, but it is again for the interest of the society, to extend the welfare to the people and to protect their interest only. So this is how the law comes into existence. And once the law is enacted, our supreme wing, second wing, that is bureaucracy, is to enforce it, is to implement it. Fine. Three most important things which I would say, I being an individual want that my interest should be protected. I should not be subjected to any hurt, harm from anybody. My property should not be subjected to damage from any angle, and my things should not be stolen, or I should not be deprived of from my legitimate right. Fine, I want as an individual. Society want that there should be a peace and harmony. Public peace and tranquility should not be subjected to any danger from any angle. Fine, and state want that it should be secured from any intrusion from the outside. Fine. Now the lawmakers have to justify societal interest, individual interest, and the state's interest as well. If you will see the provision waging war against the state, so the offense which are going to be likely to be committed against state, those are to be protected. People are to prevent to take law in their own hand and to do something which is not justifiable and which is illegal against the state, interest of the state. Counterfeiting coins. If I'll keep on publishing the currency and keep on distributing, then the economy, there would be a great slump. There would be a free flow of counterfeit coins. So the interests are to be protected. Similarly, CrPC, I will not say originally it is only a procedural or adjective law. If you will see the provision with regard to the prevention of offences and the maintenance, then you will find it's a substantive provisions. If you do not pay the maintenance to your wife who is entitled, who has been neglected, who doesn't have means of earning, and you have refused her completely, you have in fact disregarded and discarded her completely, fine, then you deserve nothing more than the jail, than the punishment. So the provision is there. So if somebody asks you that CrPC is purely procedural adjective, you will say no. There are certain substantive provisions available under CrPC. Fine. So provision of maintenance, provision of prevention of offences, that is there, right? So see, I am assuming today that since you are a student of law, you are well conversant with the basics such as bailable, non-bailable, compoundable, non-compoundable, cognizable, non-cognizable, what is final report, what is judicial proceeding, what is FIR, what is complaint. So you need to memorize the sections only now. 2A, 2B, 2R, 2D, this is what you should know. If the complaint, you must know that it is in writing or verbal, made to the magistrate only. Fine, 2D is very clear. If I say collection of evidence, to H, it should come into you. Collection of evidence means, yesterday we discussed a little. Fine. Collection of evidence. Whose prerogative it is? Police prerogative. Can magistrate investigate? No. He can authorize somebody to, on his behalf, or it's a prerogative of the police only. But the magistrate can hold an inquiry. Right. So, inquiry, trial, investigation. The minute difference you must know being a student of law. You are not to mingle up the things, not to mix up the things. So you must know it. Fine. So if I classify, I would be a bit uncomfortable here. Priya, from where do you want me to start? You are our main contender, likely to appear before the interview board. Wherever you find difficulty, you just let me know. We will start from that. And since if you ask now, then I would be very comfortable describing the things, because I do not have any fixed agenda. Fine. If you want me to make a discussion topic wise, I am ready. If you want me to discuss the provisions, I am ready. If you want me to explain the concepts only, or the way I am discussing it, I should keep on doing it, I am comfortable with. Fine. So it is what you have to decide, but still, let's discuss the overview, structure first. Fine. Then you will be very comfortable. Then we'll identify the important area and accordingly we'll proceed. Fine, Mavika? Are you getting it? Okay. See, as I said that object, extent and scope we have discussed largely. Now you have to see the classification of the courts and the power of the courts. If you will go through section 2 onward to section 13, you will find power broadly, you will say sentencing power, power of punishing somebody, Fine. So JMIC, first class, second class, CGM, and the session code you must know. Session code up to death, subject to the confirmation of the High Court. Fine. And CGM 7 year, fine no limit. And the JMIC first 1 year, first 3 years, and second 1 year. Fine. And fine is 3,000. And in the case of JMIC 2, fine is 1,000. Clear? Section 28, 9, and 30. 30 in default of imprisonment. When you have assigned somebody a substantive punishment, fine, and with fine, but fine he has not paid, then how much punishment you can inflict upon him? So 1/4 of the maximum which you can grant it. So section 28, 29, 30 you have to refer for the sentence. You can write it down. Also keep on writing whatever you feel interesting one, and so that you can refer it quickly. So you'll be, because we have very less time and we have to conclude the whole subject today itself. So you just pen down in brief. So I'm not going to discuss the courts, Metropolitan courts and the GMIC courts, that you can refer, like, you know. And then the terms which you should know, as we discussed earlier, section 2, all definitions are important. All definitions. You are not to skip anyone. Fine. Then the stakeholder you must know: public prosecutor, defense counsel, prison authorities, and the judges, and the judicial proceeding. 4 things. Fine. So section 24 to 30, which explain about the public prosecutor and additional public prosecutor. If you are going to appear for the exam of additional public prosecutor or the public prosecutor, you must know the definition. So 24 to 30 you have to memorize to know the stakeholder of the law. Fine. क्रिमिनल एडमिनिस्ट्रेशन जस्टिस के जो स्टेक होल्डर हैं उनके बारे में आपको यहाँ से पता लगेगा. Then if I classify the whole CRPC, we will be classifying into 3 categories: pre-trial, during trial, and post-trial. Fine. So let's come to the pre-trial provisions first. इसके साथ साथ जो भी हमें बेहतर लगेगा ना, हम लोग डिस्कस करते जाएंगे. ठीक है. अब जैसे पहला सब्जेक्ट आता है इसमें अरेस्ट का. ठीक है. When can police arrest without warrant? Section 41. Okay. When can police arrest without warrant? You have to refer to section 41. Fine. Now section 41 lays down certain circumstances wherein police is not required to obtain the warrant from the court. Fine. What are those circumstances? Broadly, it should be a heinous crime, severe crime. Fine. 1. It should be a cognizable offence. If he is a proclaimed offender, if he is a deserter, if he has been found in possession of some implement of housebreaking, etc., then you can, arrest him. If you know that this man is a public prosecutor, this man is a proclaimed offender and is present here, even you can inform to the police to make him arrest. Fine. The question is, can private person arrest? Can? Yes. Under what provision? 43. Yes, right. Fine. 42 again. If in case he refuses to give his name and address, clear identity, he doesn't disclose, establishes, then again he can be arrested under section 42. So provisions with regard to arrest, whether private person can arrest, whether magistrate can arrest, whether under what circumstances he could be arrested without warrant, you should know it. So 41 to section 54 you can say. Now say somebody makes a false complaint against you, say about cheating. Sir, he's due my money to the extent of say 3 lakh, 4 lakh, 5 lakh, fine. Police all of a sudden comes, make your arrest. You are not aware. You being a arrestee have to have certain rights. Because your liberty, which is a very, always kept on a highest pedestal, fine, your life and liberty, recognized as one of the fundamental rights under Article 21. If that is going to be curtailed, then you have to have certain rights. So where are those rights available? Right of arrestee. His relative, his parents, his friends should be informed. He should be informed about the right to bail. He should be informed that he can seek the assistance of a lawyer. He should be subjected to medical examination as well. Fine. So these are the certain rights which are available to the arrestee. D.K. Basu versus State of West Bengal is a landmark judgment on the subject. As good as 22 guidelines were laid down. The person who is going to make arrest, he is to prepare an arrest memo. It is to be signed by an independent witness as well. Fine. He is to carry the tag of his name because he is to reveal his identity to the detenue that I am going to arrest. Fine. He is to inform to the control room are to be established. Fine. If I come to know that my friend has been arrested, I will make a call to the police and I'll come to know that he has been arrested by such and such police and he has been detained in such and such custody, so that I could have an access to him. Right? So these are the rights which are available to the arrestee. Again, person arrested not to be detained more than 24 hours in police custody. Which section? 57. Very good. Now 57 is to be read with section 167. Right? Why so? See, police can subject somebody to torture, to beatings, can, in order to, even if he has not committed the crime, police high-headedness or excessiveness will compel him to depose what he has not done. So in order to prevent him from that brutality or agony, this provision has been incorporated, that the moment crime happens, somebody is arrested, it should be in the knowledge of the concerned magistrate, and he should be produced before the magistrate within 24 hours, because magistrate, if he cannot participate in the investigation, but he can still monitor the investigation. Yesterday we discussed area ilaka magistrate. You have one particular or two particular or three particular police stations in your jurisdiction. You have to manage, you have to monitor, you have to supervise, you have to control, right? And you have to put check on their activities as to what they are doing. Therefore, there is a provision, once the FIR is registered, it is, submitted, referred to the magistrate instantly without any delay. The magistrate is to make aware about everything. Right? Then only you can maintain the peace, harmony, law and order. So it should remain intact. It is for that purpose only. Fine. So these are some of the provisions. Section 57 say that person arrested to be taken to the magistrate. 57 says that he is not to be detained for more than 24 hours, and so on. So you can write down 41 to section 54 deals with the arrested person, and few rights of the arrestees have been mentioned under section 56, 57 and 59. माविका, समझ में आ रहा है आपको? बेटा कंफ्यूजन हो तो पूछ लेना, ऐसे हाथ रेज कर देना, कोई क्वेश्चन हो, डाउट हो, पूछ लेना, ठीक है? आई एम हेयर टू असिस्ट यू, हेल्प यू. मेरे को पता है आपके लिए थोड़ा डिफिकल्ट है, बिकॉज आपने प्रैक्टिकल एक्सपोजर नहीं लिया, किताबें ही पढ़ी हैं सिर्फ, लेकिन आपको वन डे सूनर और लेटर ये करना ही है, इसका हिस्सा बनना ही है. तो वाई नॉट एट द अर्ली स्टेज? ठीक है, तो एज अर्ली एज यू कैन स्टार्ट, यू मस्ट मेक अ स्टार्ट, यू शुड नॉट डिले इट, राइट? देन आप मजिस्ट्रेट हो, आप कहते हो उसने क्राइम किया है लेकिन वो मेरी कोर्ट में नहीं आ रहा है, तो आई वांट टू कंपेल नाउ हिम टू कम इनटू माय कोर्ट ऑफ लॉ. सो व्हाट आर द प्रोविजंस फॉर दैट? यू विल बी इशूइंग someone you will be issuing. If he doesn't come, then available warrant, then non-available warrant, then ultimately proclamation proceeding you will be initiating. Fine. So how to compel the presence of an accused in the court of law? Once you face this question, you have to answer accordingly. Sir, someone, then warrant, then proclamation proceeding, then attachment, and then if he has certain objection against the attachment, that is to be decided. So this is very important question from examination. Always asked, especially in case of your exams, because the 40-50% work which you have to do is to decide only two things. This is what? Second is trial, and third important is bail. Fine. So you must know, you must be familiar. So you can write down 61 to 69 deals with the summon, 70 to 81 deals with the warrant of arrest, 82 deals with the proclamation of personal absconding. Here there is a difference between proclaimed person and proclaimed offender. Mark my word, there is a difference between proclaimed offender and proclaimed person. ये मुझे आप याद करवाना, मैं आपको इस पर जजमेंट दूंगा एक, ठीक है? The whole concept would be clarified to you. 82.2 और 82.4 का जो डिफरेंस है वो जजमेंट में हाईलाइट किया है. In case of a heinous crime or crime which are punishable, I think more than 7 years of imprisonment, those falls under the category where the person is straightway declared as a proclaimed offender, whereas in other cases he is declared PP, person, not offender. Okay, so I'll give you the judgment on this. मुझे याद करवाना है, ठीक है? तो आप ये लिख लिया आपने. Then attachment comes under section 83. Now if somebody is aggrieved by the attachment, you have issued the attachment order, he is aggrieved, he can raise an objection. Now the property was not exclusively of him, it was of somebody else also, means there were 2-3 co-sharer, then co-sharer can also file objections to you, fine. So in 84 you entertain the objections as to the attachment. Now if you have attached the property but still the accused is not coming forward, I mean you have exhausted all the remedies, वो ढीठ है, वो नहीं आता, वो इधर बेच दो मेरी प्रॉपर्टी, then comes the sale of the property, fine. 85, release, sale and restoration of the attached property. हाँ, रिस्टोरेशन भी हो सकता है उसको, इन केस उसके ऑब्जेक्शन उसकी फेवर में डिसाइड हो जाते हैं, यू कैन रिस्टोर द प्रॉपर्टी, वो 85 में ही आप पढ़ोगे, फाइन. अगर आपने उसका एप्लीकेशन रिजेक्ट किया है रिस्टोरेशन ऑफ प्रॉपर्टी का, ही हैज़ अ राइट ऑफ अपील, दैट इज अंडर सेक्शन 86, ठीक है. सो ही कैन फाइल एन अपील अगेंस्ट योर ऑर्डर ऑफ रिजेक्टिंग द restoration of property. 87 said that you can issue warrant in lieu of, in addition to the summons, that's it. If you know that he is likely to flee or he has already fled away and his credentials are not known, now summon is not the only requirement which you have to issue, because that would be mere formality and it will cause us inconvenience and delay further and cost too, fine. The work of the court is to cut short, fine. So instead of summon you can issue the warrant straight away also, fine. 87. Then before trial the important function is during search and seizure, fine. We will read it in during investigation also, but here it is also important. Once the police comes to know that some place is being used for some illicit activities, fine. Now they should raid the premises straightway or they should obtain the warrant from the court. So usually they go to the court and say, sir, this is what we have come to know, please issue us a search warrant, we want to detect the crime and nab the culprit, fine. तो सर्च के लिए मेरा बहुत अच्छा वीडियो 10 मिनट का ऑलरेडी रिकॉर्डेड है, जिसमें मैंने सेक्शन 91 टू सेक्शन 103 सब डिस्कस किया हुआ है. इन दिस 10 मिनट्स यू आर गोइंग टू हैव अ फुल फ्लेज क्लैरिटी, ठीक है. कोई न्यूज़पेपर पब्लिकेशन हाउस है, वो वल्गैरिटी, ऑब्सैनिटी, वायलेंस और रिलीजियस सेंटिमेंट्स हर्ट करने की कुछ ऐसी प्रिंटिंग कुछ छाप रहा है, ठीक है, तो उसको आपने रीड करना है, ठीक है. आपने उसको रीड कर दिया, उसका प्रेमिसेस भी सील कर दिया, और उसके बाद में उसके पास में क्या रेमेडी है, वो कहाँ जाएगा, ठीक है. दिस इज़ व्हाट आई हैव डिस्कस इन दैट लेक्चर. नवादा प्रॉपर्टीज लेटेस्ट केस 102 लोकस क्लासिकल, वेरी फाइन जजमेंट यू विल फाइंड. द क्वेश्चन अरोज इन दिस नवादा प्रॉपर्टीज वर्सेस स्टेट ऑफ गुजरात, आई सपोज, इसको चेक करते हैं अभी, ठीक है. NAVADA नवादा प्रॉपर्टीज ऑन सेक्शन 102, latest judgment, very landmark and very fine judgment, lengthy judgment. सर्च की सारी प्रोविजन इसमें डिस्कस की गई हैं. क्वेश्चन ये आया था कि क्या ड्यूरिंग द सर्च ऑपरेशन इमूवेबल प्रॉपर्टी कुड बी सीज्ड, कैन इट बी कन्फिस्केटेड. दिस क्वेश्चन हैज बीन डिसाइडेड इन दिस कोर्ट. कोर्ट सेड एज फार एज बैंक अकाउंट्स आर कंसर्न यू कैन डू, बट द इमूवेबल प्रॉपर्टी कैन नॉट बी, बिकॉज द वेरी लैंग्वेज ऑफ द सर्च प्रोविजन्स says that with regard to the movable property you can do it, but in case of movable property you can't. So we will discuss it in regular class, ठीक है, or otherwise for your interview purpose, right. You can write it down. Navada properties 102 section judgment है. Then as we discussed that one of the pious function of the enforcement agency is to prevent the crime. तो prevention के लिए क्या है कि कोई habitual offender है, वो फर्दर क्राइम कमिट ना करे, उस पर चेक एंड बैलेंसेस रखने हैं, तो उसको पुलिस बोलती है कि आके रिपोर्ट कर, ठीक है. उसको तड़ीपार कर देती है, दूसरी स्टेट में भेज देती है, उसको अटेंडेंस के लिए बोलती है रेगुलर, या हुल्लड़बाजी ना हो, ठीक है, इस तरह का काम ना हो, सोसाइटी में एक सौहार्द और आपसी जो प्रेम प्यार है वो बना रहे और हमारी शांति जो है वो बनी रहे. तो उसके लिए आप प्रोविज़न 106 to 110, फाइन. दिस 106 इज सिक्योरिटी फॉर कीपिंग द पीस ऑन कन्विक्शन. अगर किसी का कन्विक्शन हुआ है तो उससे अपनी सिक्योरिटी लेनी है कि फर्दर क्राइम ना करे और अपने आप को रिपोर्ट करे, अटेंडेंस मार्क करे, तो 106 है उसके लिए, ठीक है. 107 आपने अक्सर सुना होगा, लड़ाई झगड़े के जो केसेस होते हैं 107 पंजा में अंदर कर देंगे आपको. सो 107 इज टू बी रेड विद 151, ठीक है. तो पुलिस के पास में एक रहता है कि यार इनको टालो, इनको दफ़ा करो, इनकी ईगो बहुत हाई है, इनको एक बार SDM के पेश कर दो वहाँ, और वहाँ ये बॉन्ड फर्निश कर देंगे और आपसे लड़ाई झगड़ा बंद कर देंगे और मोहल्ले को डिस्टर्ब नहीं करेंगे, अफरे नहीं होगा, राइटिंग नहीं होगी, ठीक है, कॉल नहीं होगा, तो सोसाइटी पीस रहेगा. तो 107 इज फॉर दैट पर्पस, राइट. 108 अगेन बिहेवियर ऑफ द पर्सन एंड उसको सिडिशियस मैटर डिसमिनेट ना करे, उसको रोकना, है ना, इस तरह से 108. एंड देन सस्पेक्ट का जो बिहेवियर है उसको मॉनिटर करना है तो 109 उसके लिए, एंड हैबिचुअल ऑफेंडर के लिए 110, राइट. दिस प्रोविजंस आर मेंट टू प्रिवेंट द क्राइम, सब्सटेंटिव इन नेचर, नॉट प्रोसीजरल, बिकॉज एग्जीक्यूटिव मजिस्ट्रेट इसमें सारी कार्रवाई उसके पास में होती है. ठीक है. देन कम दी important question for you, Rajneesh versus Neha, 125. Justice Indus Malhotra's, landmark judgment. Entire concept of maintenance has been discussed. Quantum, how to compute it, that has been discussed. Because earlier there was very vagueness, Husband used to come in a court or say, sir, I earn only 20,000 rupees. She is a quarrelsome in nature. We cannot pull on together. It is because of, her, I am suffering. So she is not entitled for. I can't give because I have to look after my old parents also, my own expenses also. There is kid also. So I can't pay. Court feel helpless. यार ये बंदा बिल्कुल ठीक बोल रहा है. अब क्या होना चाहिए इसके लिए? But at the same time, again, you are a court. You have to strike the balance. Now you have to see the pain, anxiety, and suffering of the woman also. Okay. So here you will be assessing the fault, guilt, you will be assessing the income, you will be assessing the expenses also. Fine, there has to be some state jacket formula, how much is required to the husband, fine, and how much should be given to the wife. It's a very, you can say, elegant judgment, I'll say. You must go through it. Fine. So 125, or isse pehle, whether the Muslim ladies are entitled or not, whether the lady who is living in a, say, live-in relationship, whether she is entitled or not, write down this question. You have to find out the answer. Okay? Whether the lady who is in live-in relationship is entitled, whether the Muslim woman is entitled after the enactment of the special act, whether she is entitled under section 125 or not, whether the illegitimate children are entitled, whether a daughter-in-law, the widow daughter-in-law can claim from her father-in-law. Now, once you will be having a conceptual clarity, now you will start teaching. You will say, yeah, this should happen this way. Fine. So then you will start arguing the things and you will be evolving the new things and new ideas. If you feel that, no, this is something wrong which is happening. Yes, one more judgment I have to give here. Deserter, on the ground of desertion, wife took a divorce. She has not remarried herself. Fine. She filed an application for maintenance. The Honorable Supreme Court said that she is still entitled, even if the divorce was granted on the basis of desertion. The latest judgment, I am forgetting the name, will give you today itself. इसका भी मुझे बताना, इसका भी मैं आपको judgment दे रहा हूँ, ठीक है? And the persons who are participating with us through online need not to be worried. I would be sharing these judgments with you also. Fine.
So इसमें एक और concept है ना वो that the daughter is also bound to maintain her parents.
Daughter is to maintain her parents, old age parents. See.
Daughter, married or unmarried both.
अब देखो लॉ का जो पर्पस क्या है, ठीक है, ऑब्जेक्ट क्या है. अगर डॉटर कैपेबल है और पेरेंट जो है वो उनके पास में कोई सोर्स नहीं है, ना उनका कोई सन है, ना उनके पास में कोई इनकम सोर्स है, दे शुड नॉट बी सब्जेक्टेड टू बी एट अ ट्रेजिक कंडीशंस ऑलवेज. डॉटर, नाउ आपने जेंडर इक्वलिटी कर दिया, सेक्शन 6 में लेके आए, उसमें इक्वल राइट उसको प्रॉपर्टी में दे दिया, एज गुड एज सन शी इज नाउ. इफ सन इज नॉट देयर एंड द ओल्ड पेरेंट्स शुड नॉट बी सब्जेक्टेड टू माइजरी. You have to develop your reasoning. Answer is good or bad, wrong or right, does not matter, but your reasoning should be good enough, which convinces the examiner or the court, yes, the point is there. Sir, who will look after my parents in case I am not allowed? How would they lead the rest of the life? I am their blood. They have taken care of my interests throughout. They are the one who have nourished me. They are the one who have educated me. They are the one because of whom I got married and I am living comfortably. It should be my moral, legal obligation to feed them. The court will say, okay, you are on equal footing of the son now. Even if you are married, living somewhere else, with somebody else, in some else family, still you should be very concerned with your parents because they are your root. Got my point? This is how you have to develop your reasoning. Before you read the judgment, you must know the ratio. It should have happened this way. if it has happened this way and you are not agreeing with it, what are those points? Whether court considered those points or not. Fine. So how much weightage has been given to your things, I mean your issues, your concerns and your argument and contentions, उसको कोर्ट ने किस तरह से डील किया, you must know it. This is the way of understanding the whole judgment. It is very good that you have started thinking now. Fine. तो आपकी जो एनालिटिकल स्किल्स, जो भी प्रॉब्लम आप हैंडल करो, टैकल करो, जो भी आपके सामने हो, वो इतनी वाइडेंड होनी चाहिए, है ना, कि आपको अपने हर क्वेश्चन का वाई का आपको आंसर मिलना चाहिए उसमें. Then you will appreciate the judgment. Fine. If the judgment is not a true appreciation of fact, then sooner or later that is likely to be overruled. This is what has happened in ADM Jabalpur. Justice Chandrachud, so father's judgment has been overruled by the son after a span of 20-25 years. So bad law should not be allowed to be sustained. But law is a subject which changes with the changing need of the society. Earlier, the right to privacy was not considered as a fundamental right. It is only in a Puttaswamy judgment we recognized right to privacy. In Shriya single judgments, provisions of IT Act which were curtailing our freedom to speech freely, struck down. LGBT judgment. Yes. Consensual act privately, two persons wish to enjoy, you were, I mean, criminalizing them, subjecting them to punishment. So, no, nahi chalega. Allowed. You have been introducing religion there, religious sentiment there, culture there, civilization there. These all are not above the man's will and freedom, which he has attained. How? By virtue of human being only. If I have taken birth, I need to have a right to inhale oxygen. I want free environment, fair environment. By virtue of me being human only. That is my human right. If I have taken birth in a family which is an inherited property by birth, but the moment I am conceived, you must have read in TPA, the moment you conceive, you get a right. That is a vested right. Although you enjoy that right once you become major, but you have a right in the property by virtue of you being human only. Fine. Now again, these human rights have been recognized as fundamental rights. Magna Carta in US and fundamental right here in India. Right to equality, justice, fraternity, life, number of freedoms of movement, of forming association, of speaking something. These have been right to do, free trade, business, profession, occupation, 19(1)(g). Right to property was also a fundamental right earlier, but now it's a constitutional right, 300A. Right? So, law is a changing phenomena, and we are happy enough to be blessed with this profession because we remain alive. We remain alive always. We are not the dormits. We remain vigilant, and we are the one who believe in change with the help of this tool. Right? Now, next proceed further. You have लिख लिया 110. Then maintenance provision, Rajesh versus Neha, Justice Sindhu's Malhotra judgment you have written down. 3-4 questions, and then now to maintain the law and order, 129 to 144. These provisions you have to see, like if there is unlawful assembly, you have to disperse. How to disperse? Who will pass an order? Fine. If there is a dispute with regard to the immovable property and there is a likelihood that bloodshed could take place, then how to handle? 144. Okay, the entire mechanism 144 and 145 that has been mentioned. How the executive magistrate will, take the complaint, what order he will issue, on what account, what advice he would give, and ultimately how would he close the case, and all these things you need to. So 133, 144 we have to go through here. Okay, to disperse the unlawful assembly, 133, and to resolve the dispute and to prevent the likelihood of any criminal offence which can take place on account of the dispute on immovable property, 144. Right. Now we are coming to the very important, the most important topic, investigation, information to the police and investigation. From this, see, you can expect 2-3 questions in any exam, and even in pre. This is very important. Fine. So we will take a pause for 2-3 minutes. I'll have a glass of water and then start. See, from section 154 to 159, I have already recorded a lecture. It's again 10 to 15 minutes lecture, which will give you, deepest insight about the concept. Fine. But because we have a time today, and this is an important area, Lalita Kumari judgment. First, to understand what is FIR, the information is given at first point of time to the police soon after commission of the cognizable offence. The information, whatever is given, are reduced into writing. The signature of the informant are taken, and it is signed by the maker also, and it is kept in a book which is prescribed by any state government. I will show you, this is the copy of the FIR. I do not know whether you have seen it or not earlier, but my friends, those who have been watching online can see this copy. The substance of the informations are kept in a register maintained by the state government. Herein time, place, date, occurrence, complainant's information, name of the accused, and the substance, gist of the information is mentioned. Right. Now this FIR is of 2018, dated 17th of February, and the FIR number is mentioned, and it is pertaining to the offence of 307, attempt to murder, 341, that is illegal confinement, 427, that is criminal mischief, 354, it is assault, outraging the modesty, 506, criminal intimidation, 379B, it is theft, and then 148, 149, 120B, it is criminal conspiracy, 148, 149 is unlawful assembly, more than 5 persons, 25, 27 of Arms Act means the people who were armed with the weapons and all. So under these sections, the FIR has been lodged. Complainants and accused informations and the gist of the information as to what happened, how happened, and who played what role. Again, the FIR should not be an encyclopedia of the occurrence. One, it is settled proposition of law now, but at the same time it should not be cryptic, it should not be vague, it should not be absurd, it should not be false. Fine. Now, number of questions arises as to if police refuses to register the FIR, what is the remedy? So, remedy is that you can approach the SSP, you can file a complaint before the magistrate, independent 200, 156(3), you can seek the directions from the magistrate also, and you can approach the High Court as well under section 482 for the registration of the FIR. So, these are the remedies provided to you. Fine. Now, the question is, FIR once registered, can it be quashed later? Can it be quashed? In every case? In which cases?
Very sparingly. In case it is appears to the court to be false.
Right, two judgments. B.C. Joshi versus State of Haryana. B.C. Joshi versus State of Haryana, and Kulwinder Singh versus State of Punjab. You can write Prakash Singh Badal versus State of Punjab also. See, if in case I summarize the object of the FIR, there are 2-3 objects. One, that from the informant point of view is to set the criminal law into motion. And from the investigation point of view is to give them a kick start to proceed with the investigation. Two main purpose. If I am going to lodge an FIR, I want that criminal law should be in a motion. Fine, they should proceed with the investigation. And from examination, from their point of view, that we should kick start the investigation now. We don't have any other, I mean, the you can say the way except to like proceed with the investigation. Fine. So proceeding with the investigation means proceeding to the spot of occurrence, collection of evidence, making arrest of the accused if he is there, reduce the statement into writing of the witnesses who have seen the occurrence, and then I mean form an opinion also. Fine, form an opinion also, and then ultimately prepare the challan. It is final report mentioned under section 173. We usually call it in practice challan, or somewhere it is called charge sheet also. But to my mind, charge sheet is what is being framed by the court. Fine, after accepting the challan, and when somebody is to be charged with the offences. Fine, so that is charge sheet. So here you can say it's a final report, or the word final report has been mentioned in 173. Fine, challan is not there. So final report and challan under section 173. Landmark case again 156(3), 173 judgment. I will give you Vinubhai judgment, latest judgment. Now here the question was whether the cognizance can be taken by the magistrate after, I mean, the post cognizance, like, you know. So that we will discuss in the later course. I will give you the judgment also. That's very important. So object I have clarified. Now certain important question you can mention pertaining to it. Now, is it a public document, FIR? Okay. Well, you have a right to get the copy of FIR. In which case the Supreme Court has held that it is to be uploaded within 24 hours. It is to be uploaded on the internet within 24 hours after the decision in which judgment it has been held. Earlier there was no right available with the accused to get the copy of the FIR. But हमने प्रैक्टिस में क्या देखा कि जब कभी आप बेल के लिए आते हो, आपके पास कॉपी रहती है, आप लगाते हो साथ में, तो क्वेश्चन वाज ये कॉपी आती कहाँ से? फाइन, यू कैन से एनॉमली थी ये, इसको रिमूव किया गया और अब डायरेक्शन दिया गया कि 24 आवर्स में इसको आप अपलोड करोगे. यूथ बार एसोसिएशन, it is required to be uploaded within 24 hours now. So is it a privileged statement, or somebody could be subjected to question pertaining to it? Cannot be. Can be? Yeah. यहाँ आप लिखो, it could be used only for the purpose of contradiction and corroboration. It is not a privileged document. It could be used, but who, against whom you can raise the question? Only the person who is an informant, who is an author, who is a maker, not the third person, only the witnesses. He could be subjected to contradiction. This is very important question, contradiction and corroboration. कहाँ mention है ये contradiction और corroboration Indian Evidence Act में?
145 and 157.
Very right, 145 and 157, right. A statement, previous statement which he has reduced into writing, he could be cross-examined, subjected to cross-examined with regard to that statement. And why? Just to, I mean, breach the creditworthiness of that witness. That whether he could be a reliable witness. Earlier he said something else, now he has been deposing something else. Therefore, there is a material contradiction in statement, there is concoction in his statement, there is improvisation in his statement, so he is not a reliable witness. Fine. So defense counsel has got a right to cross-examine him. Yes, if he turn out to be hostile, then even prosecution can cross-examine, contradict him on this. Okay. So you can write for impeaching the creditworthiness of the witness. Now, if the FIR has been propounded by an accused, what is the evidentiary value of the document?
Cannot be used. Only 27, section 27 Evidence Act, for the limited purposes that it can be used. Adv case.
Very nice. If a part of the statement, if he records as an FIR, led to certain kind of recoveries, then that part could be used under section 27 of Indian Evidence Act. Agnu Negacia, State of Bihar is the relevant case for that. Fine. It could be used to monitor his conduct also, to check his conduct also under section 8 of the Indian Evidence Act. Fine. It could be used as an admission under section 21 also. Fine. So section 8, section 21 and section 27 of Indian Evidence Act. if the person who recorded the FIR dies, then this statement could be used as a dying declaration under section 32(1), subsection 1. Right? If I am being subjected to a blaze, I am fighting for the life, somebody comes, take my statement, and I collapse later on. Now this, my FIR, my statement could be used as dying declaration. It is an exception to the hearsay evidence, but admissible. Okay? Exception to the hearsay evidence, but admissible, because I am no more. I cannot come into the witness box. I cannot take oath. I cannot be subjected to cross-examination. I am not more, but still I could be. Now this statement could be used. It is admissible under evidence. Right? Fine. Otherwise, if I ask, what is the evidentiary value of the FIR? Otherwise, it is a statement, merely a statement. It is not a substantive piece of evidence. Merely on the basis of the FIR, somebody cannot be punished. इसके बेसिस पे आप किसी को सज़ा नहीं दोगे ना. तो अगर ये ऐसा पीस ऑफ डॉक्यूमेंट होता जिसकी बदौलत में सज़ा दे देता, बट अब जो डैंग डिक्लेरेशन है, that carries lot of weightage. In Nirbhaya case, we have seen 3 different statements were recorded. One by the police, then by the executive magistrate, then by the judicial magistrate, and all 3 were appreciated because there was no contradiction on the statement. Okay? The version was same. So if there is contradiction in the statement, then one is required to be cautioned. Then he has been changing stand one after another. Maybe he is tutored, maybe he is influenced, or maybe he is wreaking his vengeance. Maybe he is not, true. So number of factors could happen. So FIR itself is not a substantive piece of evidence जिसके basis पे आप उसको convict करोगे, but it would be appreciated because it is a material piece of evidence. It is the information which has been given first in time to the police, and after then everything has taken place. So its value cannot be denied, but not a substantive piece of evidence. It requires corroboration, it requires evidence, it requires witnesses, it requires inspection and satisfaction of the court also. Right? See, as I said, that preliminary inquiry is a prerogative of the magistrate only, but in Lalita Kumari's, it has been held by the Honorable Supreme Court that in certain cases, there are 5 categories of cases: cases of matrimonial offences, economic offences, cases pertaining to corruption, or I think election matter, like therein the preliminary inquiry could be held by the police. Now, just for the sake of conducting the preliminary inquiry, the matter cannot be kept in abeyance. Because keep on deferring, keep on adjourning, you're not doing anything pertaining to it. The court said it is only for the limited purpose. The scope of that preliminary inquiry is very limited, just in order to see whether the prima facie case is made out or not. That's it. You cannot linger on, or you cannot, escape from your duty just on the garb of this. Fine. So this is what you have to remember. Although in Lalita Kumari's, Supreme Court has held that preliminary inquiry could be conducted, but the scope is very narrow and limited only to the extent of knowing that whether the prima facie offence is made out or not. It is not that police has to establish the guilt and innocence. It is not their job. They have to see whether the occurrence has taken place, whether whatever is saying that is true or not, whether we should record the FIR or not. It is only to this extent only. 2 judgments I will give. ठीक है, ये भी मुझे आपने याद करवाना है, इसी पॉइंट पे दूंगा मैं आपको, और ये लेटेस्ट हैं दोनों. ठीक है, इन केसेस ऑफ करप्शन it is not necessarily that police is required to wait and to conduct the preliminary inquiry. It is not so. Fine, because corruption हमारे समाज को, हमारी दुनिया को खा चुकी है बुरी तरह से. It is prevailing rampantly. So drastic measures are required to be taken to curb this menace. So the Honorable Supreme Court said no, you need not to wait. अर्लियर क्या होता था, एक पब्लिक ऑफिसर है, उसने अगर करप्शन किया है तो पहले उसको प्रोसिक्यूशन करने के लिए आप परमिशन लेते थे. दैट इज़ देयर, सैंक्शन लेनी पड़ती है. सेक्शन 19 में, इधर 197 में, CRPC में, PC एक्ट में भी प्रोविज़न है. तो अंडर दैट गाब वो सालों साल चलती थी सैंक्शन के लिए रिक्वेस्ट. ठीक है, डॉक्टर मनमोहन सिंह वर्सेस सुब्रमण्यम स्वामी का केस है इसमें. इफ़ इट इज़ नॉट ग्रांटेड, इट वुड बी डीम्ड टू बी ग्रांटेड विद इन द स्टिपुलेटेड पीरियड. दैट इज़ ऑन सैंक्शन. Because we ultimately have to curb this menace. Fine. So our society is suffering. We are suffering. So this judgment, and again another judgment I'll give you, that in case of corruption they need not to wait, for a long. Okay, and it is not mandatory that they are to held the preliminary inquiry. They can straightway lodge the FIR. This is latest judgment now. Fine, I'll give you. You are aware with the concept of zero FIR? FIR without jurisdiction? So 154 we have discussed. 155 deals with the non-cognizable offences. 156 again the power of the investigation. Police can instantly initiate the investigation without seeking permission, authority or sanction from the magistrate, because it is their prerogative. Again, the magistrate has to monitor, supervise, control it, but magistrate cannot intervene. Magistrate cannot direct that this should be conducted in this manner. That is not the prerogative of the magistrate. But magistrate has to see that whether it is being done swiftly, fastly, rapidly, without any delay, and in a fair manner. That is what you can say. If you feel aggrieved, you are a victim, fine, you lodge a complaint, but now police is not doing anything. Now you can approach the magistrate. Sir, it is not being conducted in a fair manner, so kindly look into it and issue the appropriate direction to him to do the needful in this regard. You can always do that. Fine. See, in 156(3), one is that you can approach for the issuance of direction to register the FIR or to conduct the investigation in fair manner. 2, very important, a right has been given to the victim now, because the concept of victimology is evolving nowadays. Victim compensation scheme is there, 357A, fine. Victims' interests are being taken care of by, because he is the one who is the sufferer, but he is condemned unheard at each and every stage, even at the stage of bail application also. Accused who has committed the crime comes, seek the bail, public prosecutor, because of whatever notions like he does not oppose the bail, he gets the bail, and victim remains sufferer. Fine. So that was the irony. So in order to curb it, now a lot of development is taking place. Victim is being given right even to defend, even to prosecute. Fine. There are again 2-3 judgments on this subject latest recently. A right of victim to prosecute. I'll give you these judgments too. Yes, we were talking about another implied power of under section 156(3) with the magistrate is to entertain the protest petition. Now usually what happens, once the police file the cancellation report, it is accepted. Now it is the prerogative of the magistrate whether to get agreed with them or not to agree, whether to accept it or whether to reject it. You are a magistrate, you have been performing function, one policeman, the IU, investigation officer comes to you and files a no offences made out. In this case, I have conducted the thorough investigation. You see the file, you see something, which is, you feel that, on the basis of it, that fellow should be prosecuted. You may or may not agree. You can take the cognizance of the matter yourself. Okay? Once you take the cognizance, and without even rejecting it, you are supposed to give right to hear to the victim. It is only on account of one term, odi alteram patram, that one should not be condemned unheard. Okay? It is the recognized principle of fair trial. Okay? If the accused has been given a reasonable opportunity of being heard, the same opportunity should be given to the victim as well. So he will be having a right to file a protest petition against the cancellation which has been filed by the. So it is an implied power under section 156(3) of the magistrate to decide. Right? So one video is there on protest petition. You can see that also separately we have recorded. Fine? That is what you can see. Then comes the 157. There is one schedule. Schedule 1 is provided. How many columns are there in schedule 1? Very important schedule with CrPC. There are 6 columns. Fine. The first column prescribe the offence. And section. First column section. Second column offence. Third prescribe the punishment for that offence. And fourth tells whether it's cognizable or non-cognizable in nature, whether it is bailable or non-bailable, and the fifth, and by which court is to be tried sixth. You have to memorize it for the interview point of view. They can ask you, fourth column, what does it say? Schedule 1. अच्छा, एक चीज़ मैं आपसे और पूछता हूँ. देखो यहाँ तो प्रेस्क्राइब्ड है कि कितना पनिशमेंट प्रेस्क्राइब है, ठीक है, और कौन सी कोर्ट इसको ट्राई करेगी, ये भी प्रेस्क्राइब्ड है. नाउ व्हाट अबाउट द ऑफेंसेस अंडर अदर सब्सटेंटिव लॉ? से प्रिवेंशन ऑफ करप्शन एक्ट है, NDPC एक्ट है, SC/ST एक्ट है, उनकी जो प्रोविजंस हैं वो कहाँ मेंशन है कि कौन से ऑफेंसेस बेलेबल हैं और कौन से नॉन बेलेबल हैं? डू यू नो? क्या, कितने साल, क्या बोला गया शेड्यूल 2 में, क्या बोला गया? आपके पास है BR एक्ट? शेड्यूल 2 खोलिए और शेड्यूल 1 पार्ट 2, शेड्यूल 1 पार्ट 2 देयर आर, एक ही चीज़ याद रखिए इसमें, ऑफेंसेस पनिशेबल अप टू 3 years बेलेबल, मोर देन 3 years नॉन बेलेबल। गॉट इट? पार्ट 2 में ये प्रोवाइड किया गया है। तो अभी आपके पास में अगर PC एक्ट को केस आता है एंड विच इज़ पनिशेबल टू द एक्सटेंट ऑफ 3 years, तो आप उसको बिल दे सकते हैं एज अ मैटर ऑफ राइट। फाइन, अगर इफ इट इज़ पनिशेबल अप टू 7 years, 5 years, 6 years, मोर देन 3 years, देन डिस्क्रिशन, अदरवाइज मैटर ऑफ राइट, राइट। अभी जो इंपॉर्टेंट प्रोविज़न है दैट इज़ कि अब आपका केस रजिस्टर होगा, पुलिस के पास में है, अब पुलिस को सम्मन करना है द पर्सन्स हु आर अक्वाइंटेड विद द फैक्ट अंडर सेक्शन 160, एग्जामिनेशन ऑफ विटनेसेस बाय द पुलिस। फाइन, नाउ द पर्सन हु इज़ बीइंग एग्जामिन्ड ही इज़ टू रिकॉर्ड हिज स्टेटमेंट अंडर सेक्शन 161। तो आपको अगर सम्मन आता है एज अ विटनेसेस, फाइन, इन्वेस्टिगेशन के दौरान, तो 160 का सम्मन आएगा, 161 में आप अपनी स्टेटमेंट करवाएंगे, ठीक है। फीमेल एंड द चिल्ड्रन बिलो 14 years कैन नॉट बी कंपेल्ड टू बी एट देयर premises. So wherever they feel convenient, they have to be examined there only. This is what has been mentioned, provided under the 161(2) or 161(1). And then 162, the statement is not to be signed by the person who is being examined. क्यों statement नहीं होना चाहिए साइन?
Because the police can take such a statement by use of other mechanisms, legal mechanisms, to prevent such.
Beautiful, very good, very good. The statement could be taken forcibly in order to prevent his interest. It is not to be signed because it could be read over against him in the later course of the proceedings. Fine. So therefore, it is not required to be signed as per law, and one cannot be compelled. Now here the question is, one cannot be compelled to be a witness against himself. This is what I have discussed in one of the video, which you can see the entire concept with Article 20 protection, Article 20 Clause 3 protection, and the entire concept, why he cannot be compelled to be a witness. And I have discussed even the latest judgment, that is Salvi versus State of Karnataka, that you can mention here. Fine. Brain mapping test, lie detector test, whether he could be forced, and if the evidence is extracted from him by using this scientific technique, scientific method, whether that would be inadmissible or not. So Salvi versus State of Maharashtra, it has been held that it is inhuman, cruel, barbaric, because you have been infusing something into the body of a person and he is being prompted to utter something which he never intended to. वो नहीं बोलना चाहता था, आपने उसको बुलवाया, ठीक है। So it amounts to what? It amounts to the, upliftment of the privilege which has been provided to him under Article 23. That is one of the fundamental right. So it cannot be. So 3/4 judgment here you can write. One is this. Then Kathikolu Ogad, and then before that PL Dhani's judgment. Right? PL Dhani's, Kathikolu Ogad, and this judgment. And then the important thing is that 164 provides the mechanism for recording the confession. Warning is to be given, free and fair environment is to be provided to him. If he's under some kind of shock, nervousness, that reasonable time is to be provided to him. Then one para from the magistrate side that he was insured and he was given repeated warning, and I ensure that I have he has deposed voluntarily. Fine. So the magistrate has to make every possible endeavor that he deposes voluntarily, freely, with his free will, and they should not be fair. Fine. And if he is handcuffed, that handcuff should be removed, and if there are policemen available, they should be sent out. Fine. So this is the procedure and mechanism has been provided under section 164 as to how to the confession. See, confession is that somebody is making the statement against his interest. Fine. Now, why he is making? The magistrate has to ensure that it was voluntarily and with his free will. There was no pressure, influence, threat, or any kind of promises exercised upon him. Fine. So this is the thing which is to be given. 164 is very important again from the examination point of view. Prosecutrix is also examined under this section. Not only the confessional statement, but otherwise a general statement could be made under section 164. Why? See, in law, you are to satisfy your why first. This is very, very important. Fine. Every provision has been enacted for some object or purpose. Make it very clear. We are not going to read history here. कि राजा ने वो किया था, उसकी कितनी रानियाँ थी, एक रानी बहुत खूबसूरत थी, फाइन, और राजा को शिकार का शौक़ था. ये वो कहानी नहीं है. ये कहानी वो है जो लॉ मेकर्स ने डेलिब्रेशंस करके आपके सामने प्रस्तुत की है टू प्रिवेंट द इंटरेस्ट ऑफ द सिटीजन, टू एक्सटेंड देम अ वेलफेयर. फाइन. सो देयर इज़ अ पर्पस एंड ऑब्जेक्ट टू स्ट्राइक द बैलेंस अमंग्स ऑल द इंटरेस्ट्स, स्टेट, इंडिविजुअल एंड एक्यूज्ड. सबके इंटरेस्ट को बैलेंस करने के लिए प्रोविजंस इनकॉर्पोरेट हुई हैं. तो एवरी इनेक्टमेंट, एवरी प्रोविजन हैज़ सम पर्पस. सो यू आर टू गो देयर. What is the intent of the legislation you need to see first, then you will be having clear cut understanding. So if I say that prosecutor's statement is recorded here, why? What is the need?
Section 162 के बाहर से it comes out and you can use this statement for corroboration as well at later stages of trial.
Yes, fine, fine. See, later on there may be a situation because when the crime happens, it not only hit hard physically but also mentally. She may decide not to come to the court of law again. She may dislocate herself somewhere else in order to prevent from the stigma, stare which is being caused by the society. She is already a victim and she is again being victimized by the people, and she is being looked after with a very, the lower sort of thing, So she would always avoid it. She may not be available. Now the guilty who has already committed this crime, court want that he deserve punishment and he should be. So this is the requirement. The statement of the prosecutor should be recorded at first hand. She may be influenced later on. She may be bribed later on. You must have noticed now, you get married, you tie Rakhi, this kind of observations are being made. Although this is very pitiable things, should not happen, but proposals are being given. Right? Now to condone such a heinous crime, you have been proposing somebody to get into these kind of arrangements. That is very ill state of affair. Sordid moment, we can say, बहुत ये है, but should not happen. So just in order to protect the interest of an individual with whom the heinous crime has been committed, and person who is guilty of such an heinous crime, that the conviction could be secured for him, therefore it is mandatory to record the statement of the prosecutrix at the earliest stage. Therefore this provision was incorporated. Fine. So your answer, Priya, should be very clear when you have to appear before the interview board. Fine. Now to investigate this kind of matter, the time limit has been revised. It is 60 days now. Earlier, the offences which are punishable to more than 10 years, 90 days is provided. But now it has been changed. Now to curb the crime and to make the investigation effective and speedy, this has been mandated that it should be concluded within 60 days. Yes, it should be completed within 60 days. 165 talks about the search. Although I said that I have already recorded a video, you need to watch that. In that video, I have explained everything. General provisions are same under section 100 and 102, general. But this is during investigation, that is before trial. Otherwise, fine, that is the only difference. Then this topic I would love to explain in detail because this is very important nowadays. The matter is pending with the Supreme Court, that is 167 default bail, remand. Usually we call it remand. Remand means to resend. Resend to whom? The accused who has committed crime, either to the police custody or the judicial custody. One landmark case which you need to write, wherein you will understand the whole process of 161, CBI versus Anupam Kulkarni. Landmark on the subject. Arrest is not been defined anywhere. Custody has not been defined anywhere. This is first time in this judgment these words were coined and explained. Fine. So could it be interchangeable, like up to for how many days it should be? 15 days maximum. Can it be interchanged? Police custody, judicial custody, then police custody, then judicial custody. Can it be? You will find the answer in this judgment. We will discuss on the last day then. क्या पढ़ा है आपने? This is your homework actually. ठीक है, मैं तो 1 मिनट में 2 मिनट में आपको क्रश बता दूंगा, ठीक है, but you need to exercise. So CBI versus Anupam J. Kulkarni 1992 case. One more case which you have to write is Dinesh Dalmia versus CBI 2007 case. Yes, my online friends, Dinesh Dalmia versus CBI. Concept of investigation, reinvestigation and further investigation you have to understand. Fine. Now ये जो आप 156(3) की जजमेंट की बात कर रहे थे ना, पोस्ट स्टेज कॉग्निजेंस, इसको 173(8) में भी हमने पढ़ना है, तो ये मुझे आपने याद करवाना है, मैंने आपको ये जजमेंट देनी है, ठीक है। इसमें यही कॉन्सेप्ट डिस्कस हुआ है एक्चुअली। देखो क्या है, पुलिस आती है, उसने चालान पेश कर दिया, बट उसका इन्वेस्टिगेशन अभी चलता रहता है, उनका वो सोल प्रेरोगेटिव है 173(8) का, कि फर्दर इन्वेस्टिगेशन दे वुड कीप इट कॉन्टिन्यूड। कोई नया सुराग मिल गया, कोई नई एविडेंस मिल गई, कोई और बंदा इन्वॉल्व था वो मिल गया, उसने कुछ आके डिपोज कर दिया नया, तो आप उसको रोक नहीं सकते हो, दैट इज़ द प्रेरोगेटिव। नाउ क्वेश्चन वाज वेदर दे रिक्वायर टू सीक अ परमिशन फ्रॉम द मजिस्ट्रेट, द आंसर वाज बिग नो, दिस इज देयर प्रेरोगेटिव, ठीक है। हुआ क्या, किस प्रोविज़न को उन्होंने मिसयूज़ करना ऐसे स्टार्ट किया कि 60 डेज 90 डेज में आपको इन्वेस्टिगेशन कंप्लीट करना है, आप 60 दिन के अंदर में इन्वेस्टिगेशन रिपोर्ट लेके आए, जस्ट कि वो बंदा बाहर ना आए, बेल आउट ना हो, विच इज़ इनकम्प्लीट इन नेचर, जो कंक्लूडेड नहीं है, ठीक है। नाउ आई एम अ मजिस्ट्रेट, आई एक्सेप्ट द रिपोर्ट एंड मैंने जो उसका स्टैट्यूटरी और कॉन्स्टिट्यूशनल और लीगल राइट था टू बी रिलीज्ड ऑन बेल इन केस ऑफ फेलियर टू प्रोड्यूस द रिपोर्ट, ठीक है, मैंने वो कर्टेल कर दिया, लिमिटाइज कर दिया, ठीक है, और मैंने वो रिपोर्ट एक्सेप्ट कर ली। पुलिस अगेन फ्री है, अब कहती है जी हम तो जब मर्जी जाके सप्लीमेंट्री चालान पेश कर देंगे कोर्ट को, ये क्वेश्चन था। अब तो पुलिस सालों साल अगर इन्वेस्टिगेशन ही ख़त्म नहीं करती है तो हमारा केस की डिस्पोजल कब होगी और उन लोगों को इंसाफ कब मिलेगा? तो दिस वाज द मेन थिंग बिकॉज ऑफ विच द डिले वाज अकरिंग। तो वो सारे फैक्टर जो डिले कॉज करते हैं और डिस्क्रिशनरी राइट देते हैं इंस्टेड ऑफ फॉलोइंग द मैंडेट और द प्रोविज़न और द स्टैट्यूटरी प्रोविज़न, और स्मार्ट और क्रुक प्ले करते हैं, क्लेवर मोड प्ले करते हैं, एक्सरसाइज करते हैं, उनको कर्व करने के लिए ये जजमेंट है जिसका मैं रेफरेंस आपको भी दूंगा, ठीक है। दिस 2 जजमेंट्स आर वेरी वेरी इंपॉर्टेंट अगर आपको अरेस्ट, कस्टडी, डिटेंशन और रिमांड और बेल, डिफ़ॉल्ट बेल समझना है, पहले तो ये 2 जजमेंट्स हैं, ठीक है। तीसरी जो लेटेस्ट जजमेंट है वो पोस्ट कॉग्निजेंस स्टेज पे जो फर्दर इन्वेस्टिगेशन वेदर इट कुड बी ऑर्डर्ड और नॉट, नाउ इट हैज़ बीन अलाउड टू द मजिस्ट्रेट आल्सो, ही कैन आल्सो ऑर्डर द फर्दर इन्वेस्टिगेशन, ठीक है। 173(8) का जो प्रॉस्पेक्ट है उसको भी हम समझने की कोशिश करेंगे। सो दीज 2 जजमेंट्स हैव रिटन। इसमें ये क्वेश्चन हुआ था, जजमेंट आपका नाम लिखिए, उदय मोहन लाल आचार्य वर्सेस स्टेट ऑफ महाराष्ट्र, 2001 का जजमेंट है ये। अब क्या है, 60 दिन कंप्लीट हुए, इधर से एप्लीकेंट अक्यूज का बेल एप्लीकेशन आया कि सर मेरा इंडिविजुअल राइट है बेल का, आई बी ग्रांटेड, सेम डे चलान आ जाता है। नाउ यू आर अ मजिस्ट्रेट, यू हैव टू डिसाइड इट, फाइन। सो हियर इन दिस जजमेंट इट वाज हेल्ड that it is obligated on the magistrate to release him on a bail, right? So this judgment you have to go through. Now in one of the judgment it has been held that it is not mandatory for the applicant accused to file an application. मान लो एप्लीकेशन ही नहीं आता, 60 दिन कंप्लीट हो चुके हैं, 61st डे और 60 डेज़ को 60 डेज़ कंप्लीट होते ही चार्जशीट भी चलान भी आ जाता है। अब क्या उसका राइट ख़त्म हो गया अगर उसने एप्लीकेशन फाइल नहीं किया? तो उसमें ये हेल्ड किया गया कि नो, बिकॉज इट इज़ अ कॉन्स्टिट्यूशनल स्टैट्यूटरी राइट, इट विल रिमेन इंटैक्ट इफ द चालान इज नॉट फाइल्ड विद इन द स्टिपुलेटेड पीरियड, then still he is entitled for bail even if he has not preferred the bail application. This is very important from your interview point of view. It is indivisible right. It is not that he was sleeping. In Sanjay Dutt case, it happened. He lapsed this opportunity. Challan did not file. His advocate remained, idolent. He did not move an application. His right was defeated. But now in this judgment, it was held even if he has not filed an application under section 167(2) for default bail, still he would be entitled. Because see reason समझिए यार, मैं पुलिस ऑफिसर हूँ, मेरे ऊपर में एक ऑब्लिगेशन है कि मुझे इस केस में 60 डेज में और इस केस में 90 डेज में चलान देना है. अब मैंने फॉल्ट कमिट किया, मीन्स आई रिमेन एट डिफ़ॉल्ट, देयरफॉर डिफ़ॉल्ट बेल इमर्जेस. फाइन. तो मेरी इन एफिशिएंसी की वजह से, ठीक है, अगर उस इंसान को बेनिफिट हो रहा है तो होना ही चाहिए, बिकॉज इट वॉज माई लीगल बाउंडन ड्यूटी टू कंप्लीट द इन्वेस्टिगेशन विद इन दिस टाइम फ्रेम. I got failed. He is entitled for the benefit. Even if he doesn't file an application in writing, court has to see, because court is not only the moot spectator. Court is there to render justice. Fine? Yes, मुझे मेरे फाइन, मुझे पेनल्टी, मुझे फोरफीचर, मुझे जो मर्जी आप इम्पोज करो, बट उसका राइट जो है वो इंडिविजिबल राइट है. मैंने नहीं, उसको कॉन्स्टिट्यूशन ने दिया है, बिकॉज इज राइट एंड लाइफ एंड लिबर्टी शुड नॉट बी कर्टेल्ड अननेसेसरली. आर्टिकल 21 उसकी वायलेशन है. देन स्टैट्यूटरी प्रोविजन ये बोल रही है आपकी 167(2) कि 60 दिन और 90 दिन. आप मुझे भी नहीं रख सकते, आप छोड़ो, ठीक है. वो जजमेंट मैं आपको देता हूँ. नाउ विद रिगार्ड टू द कंप्यूटेशन, फ्रॉम विच डेट इट इज़ टू बी कंप्यूटेड. तो अर्लियर द व्यू ऑफ फ्यू कोर्ट्स वर दैट फर्स्ट डे शुड बी एक्सक्लूडेड व्हेन ही इज अरेस्टेड. It is to be counted from the period when his detention is authorized by the magistrate, whenever he is produced. It should be from that day. But there was divergent view of various high courts. Now the matter is pending with the Supreme Court. It has been referred to the larger bench, from which date it is to be computed. If any, in case anybody asks you that from which date the period of 60 or 90 days is to be computed, he says that there were divergent view, fine, and the matter is now pending with the larger bench. These judgments what I have, इसके साथ में एक संजय दत्त वाला केस भी आप मेंशन कर सकते हो, ठीक है. एक कभी सिचुएशन इमर्ज हुआ कोविड के दौरान, दे स्टार्टेड मेकिंग अ प्रोटेक्स्ट कि सर ड्यू टू कोविड वी आर नॉट गोइंग टू इन्वेस्टिगेट मैटर इफेक्टिवली इन 60 days or 90 days. The court said now the person should not remain on your mercy. You are making this pretext, tomorrow you can make another pretext. तो here the केस का नाम लिख लीजिए आप, सेतु वर्सेस स्टेट. हाँ, सेतु वर्सेस स्टेट. सुप्रीम कोर्ट ने इस रीजनिंग को अप्रूव किया है, सेतु वर्सेस स्टेट को. इसमें यही बोला गया दैट जनरल एक्सटेंशन ऑफ लिमिटेशन पीरियड विल नॉट इफेक्ट द राइट ऑफ अक्यूज्ड. देन कॉन्सेप्ट ऑफ ट्रांजिट बेल यू नीड टू, ये कॉन्सेप्ट अभी इमर्ज हुआ ये दिशा के केस में. राइट, transit bail, anticipatory transit bail and regular transit bail. This is the bail by a court not having jurisdiction over the place of offence. मान लीजिए ऑफेंस हुआ चंडीगढ़ में, बंदा जाके छुप गया कानपुर में, वहाँ पता लगा पुलिस को, उसकी अरेस्ट डाल दी, ठीक है. तो वहाँ क्या वो बेल के लिए इंटाइटल्ड है, वहाँ फाइल कर सकता है, नहीं कर सकता, तो ट्रांजिट बेल, ठीक है. तो अगर वो अंदर है तो रेगुलर है, अगर वो बाहर है तो एंटिसिपेटरी ट्रांजिट बेल है, ठीक है. इसमें आप यू कैन राइट डाउन वन केस, हनीप्रीत इंसांग वर्सेस स्टेट, जो बाबा राम रहीम का जो है ना, हनीप्रीत इंसांग ट्रांजिट बेल में, आपको समझ में आ जाएगा ये सारा कॉन्सेप्ट. सी presumption ऑफ इनोसेंस इज ऑलवेज अटैच्ड विद द एक्यूज्ड. फाइन, हिज गिल्ट इज येट टू बी प्रूव्ड, ही इज नॉट अ गिल्टी येट, बट फॉर हाउ लॉन्ग ही इज टू बी रिमेन इन अ कस्टडी, दिस इज द पैरामाउंट कंसिडरेशन बिफोर यू एज अ जज. If he is involved in a heinous crime, he doesn't deserve the concession of bail, and you feel that he will not stop his illicit activity even after getting released from the jail. He will tamper with the evidence, he will influences or threaten the witnesses, or he will manipulate the documentary evidence, etc. Fine. So he doesn't deserve and should not be entitled. He should be confined to the jail. In how many cases he is involved, and what are the nature of the cases, whether he is earlier convicted or not, these all points you have to consider being a judge while granting the bail. Right? In section 437, magistrate is empowered, but again he can exercise the discretion and impose certain conditions also. I asked you one question like cancellation. It is in 437(5) with the magistrate and 439(2) with the session and high court. Remember it. ठीक है. Bail, cancellation of bail with the magistrate where he has to exercise the discretion, that is 437, and regular bail before the session court 439, before the high court again 439, cancellation 439(2) with both the court and 437(5) with the magistrate. ठीक है. No confusion anymore यहाँ. ठीक है. 436 right of bail उसका है ही है. 436A is one provision which says that if somebody is being tried for an offence of say cheating, the prescribed punishment is 7 years, 1.5 years already suffered, now you are supposed to release on bail. So yesterday I asked you कि कुछ ऐसी सिचुएशन और कंडीशंस बताओ जहाँ पे उसका मैटर ऑफ राइट बन जाता है बेल का. दिस इज वन ऑफ द कंडीशन 436A. ठीक है. 167(2), 436A and 436. एंड एक इसमें देखना कॉन्सिक्वेंसेज ऑफ जंपिंग बेल. आपसे अक्यूज ने रेगुलर बेल लिया, उसके बाद वो टर्न आउट नहीं हुआ. नो व्हाट आर द कॉन्सिक्वेंसेज ऑफ दैट. 229A लिख लो इसमें आप. कॉन्सिक्वेंसेज ऑफ जंपिंग द बेल 229A. अगर उसने बेल जंप कर दिया ना तो 1 साल का इम्प्रिजनमेंट और दोगे आप उसको. ठीक है. इस सेक्शन के तरह IPC 229A IPC. आपको मैंने कल 4 जजमेंट प्रिया वो लिखवाई थी, अर्नेश, राजेश, वो सब लिख ली थी आपने, मानव अधिकार एंड ऑल. वो लिखी आपने, समझी, जानी, पढ़ी. मुझे बताओगे अर्नेश क्या कहना चाहता है एक लाइन में. अर्नेश वर्सेस स्टेट ऑफ बिहार में सुप्रीम कोर्ट ने क्या बोला 2014 में. वेरी इंपॉर्टेंट जजमेंट फ्रॉम इंटरव्यू पॉइंट ऑफ व्यू. देखो मैं आपको एक चीज़ बोलता हूँ. ऑफेंस कमिट हुआ, द कॉम्प्लिसिटी, इन्वॉल्वमेंट, एट्रीब्यूशन, everything is yet to be adjudged. Suppose there are 3, 4, 5 persons. One person role is this much only. The person who is a principal offender, his role is this much only. Fine. Now principal offender has been arrested. He has been making the disclosure statement to the police that Mr. So and so, so and so, so and so was also involved with me. Now this Mr. is not even acquainted with the gentleman, but he just wanted to, wreak his vengeance against me. Some rivalry he wanted to settle. He wanted to settle some personal score with me. He named me. I am not at all involved. Police come all of a sudden and arrest me. Anesh Kumar, State of Bihar says no automatic arrest. Fine. No automatic arrest, but उसमें क्या था, कन्फाइन था. उसमें कन्फाइन ये था कि ओनली इन केसेस परटेनिंग टू 498A. होता क्या था कि लड़की कंप्लेंट देती थी मेरे साथ क्रूरल्टी हुई है, माल ट्रीटमेंट हुई है, डोरी डिमांड के नाम पे हरासमेंट हुई है, और वो हस्बैंड नहीं पूरी फैमिली इन्वॉल्व हो जाती थी. सिस्टर इन लॉ, मदर इन लॉ, फादर इन लॉ, एवरीबडी, और वो सबको अरेस्ट कर लिया जाता था. ठीक है. तो ये प्रैक्टिस कोई 10-15 साल तक चली हिंदुस्तान में. ऐसा ही होता था. तो अनेश कुमार स्टेट ऑफ बिहार में फर्स्ट टाइम बोला गया कि नो ऑटोमेटिक अरेस्ट इन केसेस ऑफ 498A. फाइन. ठीक है. अब इसमें द IO इज टू सेटिस्फाई, द कोर्ट इज टू सेटिस्फाई द नेसेसिटी ऑफ मेकिंग अरेस्ट अंडर सेक्शन 41. ये नहीं कि आप किसी का भी इमेज रेपुटेशन जो है टार्निश कर दोगे, इवन इफ दे आर नॉट एट फॉल्ट. ठीक है. तो कॉशन एंड नोटिस एंड देन योर सेटिस्फेक्शन एंड रीजन to be recorded in writing as to why you are making the arrest of a fellow. ठीक है. एंड इसमें ही ये बोला गया था कि इन केसेस विच आर नॉट पनिशेबल टू द एक्सटेंट ऑफ 7 ईयर, उसमें रूटीन अरेस्ट नहीं करोगे आप. देखो, इट इज़ अ वेरी वैल्यूएबल राइट, इट्स अ फंडामेंटल राइट. इट शुड नॉट बी curtailed otherwise just by somebody is alleged against me. Fine. I should be implicated, arrested and subjected to prosecution and ultimately punished. No. There is a parameter, there is a framework which is required to be followed. तो एक तो no automatic arrest in cases under section 498A. Second, no routine arrest in offences punishable with less than 7 years of imprisonment. There is one provision incorporated under section 41A. It has been added now, amended. Fine. What does it say? Notice be given to the accused to appear and participate in investigation. This has been held in Amandeep Singh Johor's, दिल्ली का केस है, अमनदीप सिंह जोहर्स केस. मतलब इसका प्रोएक्टिव यूज़ करना हमने 41A का। अगर आईओ को मेरी रिक्वायरमेंट है, उसको लगता है कि मैंने कोई ऑफेंस कमिट किया और मैं अक्यूज्ड हूँ, आई शुड बी गिवन फेयर अपॉर्चुनिटी टू पार्टिसिपेट, टू ज्वाइन द इन्वेस्टिगेशन, सो दैट आई कुड put forward my viewpoint. It is only in the cases which are punishable to the extent of 7 years or less, right? So इस जजमेंट को भी आप लिख लीजिए। फिर एक केस था राजेश शर्मा वर्सेस स्टेट ऑफ यूपी 2018 में। इसमें certain directions were given by the Supreme Court. One of the direction was to form a family welfare committee कि जो DLSA है, डिस्ट्रिक्ट लीगल सर्विस अथॉरिटी, वो एक फैमिली वेलफेयर कमेटी फॉर्म करेगा, ठीक है, और जो भी 498 का कंप्लेंट होगा वो उनको रेफ़र किया जाएगा। विद इन 1 मंथ जो कमेटी है वो डिसाइड करेगी, एंड एट द मीन टाइम कोई अरेस्ट नहीं होगी और एलिगेशंस की वैलिडिटी को टेस्ट किया जाएगा, चेक किया जाएगा, और उसके बाद में जो है फॉर्मल एफआईआर रजिस्टर्ड होगी। ये मैकेनिज्म प्रोवाइड किया गया था राजेश शर्मा वर्सेस यूनियन ऑफ इंडिया में, ठीक है, इन 2018, बट इट वाज अगेन चैलेंज्ड। मैटर वाज पुट बिफोर 3 जजेस बेंच। इट वाज 2 जजेस बेंच डिसीजन, राजेश शर्मा। इट वाज चैलेंज इन सोशल एक्शन फोरम फॉर मानवाधिकार वर्सेस यूनियन ऑफ इंडिया। सोशल एक्शन फोरम फॉर मानवाधिकार वर्सेस यूनियन ऑफ इंडिया इन 2018। अब जो ये कंडीशन थी टू फॉर्म अ फैमिली वेलफेयर कमेटी, फाइन, दिस वाज स्टक डाउन, दिस वाज होली स्टक डाउन इन दिस केस, मानवाधिकार एक्शन में। उसका रीज़न समझिए क्या है। बोलते ये जो मैकेनिज्म है टू इनेक्ट दिस स्टैट्यूटरी प्रोविजन इज द प्रेरोगेटिव ऑफ द लॉ मेकर, दैट इज द लेजिस्लेचर ड्यूटी। इफ कोर्ट वुड बी opining that this mechanism should be adopted rather than the statutory provision, then it will transgress the power of the legislatures, which is not permissible under constitution. So therefore this exercise, I mean this opinion of forming the welfare committee was struck down, fine. So partly this judgment was struck down. Thank you very much to the online viewers. They have been appreciating our class, the kind of insight we have been providing here. I am so grateful and happy. I mean, remain in a constant touch with us. We are there for 6-7 days. You would be getting a bundle of information, huge information, fine. And if you really want to join the main course, we would be starting it from 1st of June. Not before that, but you can really enroll yourself for the guided tour. I mean, the concerned person from our office, she will contact you after this lecture, and you can express your, views, and she will explain the detail as to how to join, when to join, and what you need to do in these 2 months. So you first enroll for guided tour, wherein you would be provided certain material which you have to prepare on your own. Once you will be preparing and here you come, then only we will be confirming your seat. We want good quality, refined students like you who can do justice to our teaching and give their valuable efforts, time with full energy and zeal. You are most welcome. Thank you very much. You have been admiring it. Keep watching. I think default we have done, 498 we have done. Yes. On anticipatory bail, you can write down few judgments. See, it means the bail in anticipation. Anybody who is apprehending threat of being implicated or being arrested by the police can approach the court stating, sir, I am innocent, I have not involved in this crime, my name has been otherwise taken, and in case I am arrested, my image and reputation would be tarnished completely and irreparable loss would be caused to me. So I am ready to join the investigation. I am ready to answer the charge or the question, whatever has been framed against me. I be given concession. So keeping in view the averments, assertions, and the contentions you are making in your bail application, court may consider it sympathetically and can grant you the concession of bail. It is again your right provided under section 438. Fine. It is the power is with the session court and the High Court. Now the question is whether you should approach the session court first and then come to the High Court, or you can straightway come to the High Court, because it is the concurrent power which has been provided. Fine. So herein you should try to approach the session court first. Fine, it is a prudent approach. But if the circumstances does not allow and it is so compelling, circumstances are so compelling that you need not have any other remedy except an efficacious remedy available before the High Court, then you should instantly come to the High Court. There is no embargo upon you that you can't approach it. You can approach, but you need to justify as to why did not you approach the court at first point of time which was available there. So you can write down the parameters and the guidelines to grant this bail, which has been laid down in Gurbakh Singh Sibia versus State of Punjab 1980 judgment. Gurbakh Singh Sibia versus State of Punjab, landmark judgment on this. Now the question arises here is whether it should be for a limited time or it should be for an unlimited time. In Gurbakh Singh Sibia, it was held that it should be for unlimited time, but if court feel that nature of crime is such and credentials of the offender is such, he should be limitized. Fine. So again this controversy emerged in a case of Salahuddin Abdul, ये भी लिख लीजिए आप, Salahuddin Abdul Samad Sheikh versus State of Maharashtra. तो इसमें ये बोला गया कि लिमिटेशन जो है दैट शुड बी लेफ्ट टू दी कोर्ट ग्रांटिंग द एंटिसिपेटरी बेल. इस केस में ये बोला गया था. फाइन. देन आया आपका SS Mahatरे वर्सेस स्टेट ऑफ महाराष्ट्र. दिस इज अगेन गुड पीस ऑफ जजमेंट. Now the constitutional bench judgment which you have to memorize for the time to come is Sushila Agarwal versus State of NCT Delhi. This is 5 judges bench unanimously ruled that protection granted to a person under section 438 CrPC should not invariably be limited. Fine. So it is for an unlimited time. Earlier क्या होता था मैं आपको बता देता हूँ. हम एंटिसिपेटरी बेल हाई कोर्ट से लिया. अब जहाँ पे कोर्ट पेंडिंग है ट्रायल कोर्ट में, चाहे वो मजिस्ट्रेट की कोर्ट में है या सेशन की कोर्ट में है, वहाँ आपको जाके रेगुलर बेल फर्निश करनी पड़ती थी. ठीक है. दिस इज़ नो मोर रिक्वायर्ड. एंटिसिपेटरी वंस गिवन, नो लिमिटेशन, इट इज़ नॉट रिक्वायर्ड. वी नीड नॉट टू. फाइन. इट इज़ फॉर वंस एंड ऑल. फाइन. तो इसी में यही होल्ड हुआ सुशीला अग्रवाल वर्सेज एनसीटी दिल्ली में. 5 जजेस बेंच डिसीजन है ये. Protection granted under section 438 CrPC should not invariably be limited to a fixed period unless special case made out. तो यहाँ भी जो unless special case made out है ना, वो जो मैंने पहले डिस्कस किया वही है. ठीक है. स्पेशल circumstances, nature of crime, gravity of offense, number of other things. एक इसमें इम्पॉर्टेंट एस्पेक्ट और डिस्कस हुआ. मान लो सुशीला अग्रवाल में मैंने एंटिसिपेटरी बेल लिया, मैं इन्वेस्टिगेशन ऑफिसर के पास में इन्वेस्टिगेशन ज्वाइन करने चला गया, मैंने कोई स्टेटमेंट सफ़र किया, उस स्टेटमेंट की बदौलत कोई रिकवरी हुई विच इज़ एडमिसिबल अंडर सेक्शन 27 ऑफ इंडियन एविडेंस एक्ट. दैट इज एडमिसिबल. ठीक है. नाउ द क्वेश्चन इज कि वेदर ही वुड बी डीम्ड टू बी इन अ कस्टडी ऑफ द पुलिस. ही इज एन एंटिसिपेटरी बेल एंड 27 कब आपका एडमिसिबल होगा? जब वो कस्टडी में है. डिस्क्लोजर तभी वो रिवील करेगा अपना. ठीक है. तो कोर्ट ने इसमें होल्ड किया कि limited custody or deemed custody which the police has, this is a very important point, over the accused would be sufficient for the purpose of fulfilling the provision of section 27. So it is not mandatory now that he should be in actual physical custody of the police. Then only he can make the disclosure. Fine. If he is in a constructive custody and his statement leads to some recovery, that would be admissible under section 27. A very important point. Very, very important. So the fact is that now the prosecution claim the benefit. If he suffer the statement under section 27A, even if he is not in a physical actual custody of the police, now they can claim the benefit. Prosecution can claim the benefit in regarding the recovery. एंड सी अगर आप जज हो सेशन कोर्ट के, एंटिसिपेटरी बेल आपके पास में आता है, कोई भी क्राइम अगर कमिट हुआ है, तो व्हाट आर द पैरामीटर एंड गाइडलाइंस विच वर हाईलाइटेड इन SS महात्रे एंड गुरबख्श सिंह सेगिया. आप 2-3 लाइन में लिख लीजिए वो. ठीक है. फिर कंक्लूड करेंगे, फिर हम पोस्ट लंच लेते हैं इसको. ठीक है. आप लिख लीजिए वो. सी सबसे पहले तो नेचर एंड ग्रेविटी ऑफ द ऑफेंसेस टू बी टेकन, टू बी कंसीडर्ड कि एक्यूजेशन क्या है और अक्यूज का रोल कितना, रोल ऑफ द अक्यूज्ड. Accusation against him and the role of the accused. Antecedents of the accused. previously undergone or not undergone, previously convicted or not convicted, or involved in any other case or not, है ना. तो ये how many cases are registered against him. Then possibility of him being fleeing from the justice. भाग तो नहीं जाएगा वो बंदा, इन्फ्लुएंशियल है, पैसे वाला है, पासपोर्ट उसके पास में है, 2-3 कंट्रीज़ में उसके लिंक हैं, रिलेशंस हैं, रिलेटिव हैं, और एक्सेस है उसको इजीली, पहले वो टू एंड फ्रो किया हुआ है, ठीक है, बट हीनियस क्राइम में इन्वॉल्व है, उसके पॉसिबिलिटी कितनी है भागने की. दिस इज़ व्हाट वी हैव टू कंसिडर व्हेन व्हाइल ग्रांटिंग. देन likelihood of committing or repeating the same offense or the similar offense, similar or other offenses. Right? Likelihood of committing and repeating the similar or the other offenses. अगर मैं पॉजिटिव पॉइंट देखूं तो यार इसके अगेंस्ट में जो एक्विजिशन हुआ वो गलत तो नहीं है, झूठा तो नहीं है, वो बेबुनियाद तो नहीं है, वो उसके करैक्टर को इम्प्यूट करने के लिए तो नहीं किया गया, खाली इसलिए तो नहीं किया गया कि वो इन्फ्लुएंशियल है और वो पैसा देगा और अपना स्कोर सेटल कर लेगा. तो नंबर ऑफ फैक्टर्स, राइट. यू बीइंग अ जज हैव टू थिंक फ्रॉम बोथ एंगल्स, दोनों एंगल से सोचना है आपने, ठीक है. देन फिर वही जो हमने पॉइंट जनरल डिस्कस किए हैं कि पॉसिबिलिटी ऑफ टैम्परिंग द डिफरेंसेस, टैम्परिंग द एविडेंस, threatening the witnesses, influencing them. I mean, these are the points which you have to keep in mind, like, you know, while granting or while considering his bail application. So when I am teaching you, I am considering you judges only. So therefore I am referring you over and again. Even मैं तो आपको हाईएस्ट पेडिस्टल में ले गया सेशन कोर्ट में, इसीलिए मैं एंटिसिपेटरी बिल डिस्कस कर रहा हूँ आपके साथ. देन मटेरियल जो रिकॉर्ड पे अवेलेबल है, जो पुलिस ने आपको दिया बना के ड्यूरिंग इन्वेस्टिगेशन, वो आपके पास में रहेगा, ठीक है. उसको भी आप अप्रिशिएट करोगे. यू विल परयूज़ द फाइल एंड यू विल सी कि एक्विजिशन का सीरियसनेस कितना है और इस इंसान का रोल कितना है उसमें, ठीक है. एंड देन अल्टीमेटली एलिमेंट ऑफ जेन्युइननेस कितना है कंप्लेनेंट की तरफ से, ठीक है. जैसे अभी हमने 498 की बात की कि सभी लोगों को इम्प्लीकेट करते थे, चाहे वो फार अवे रहती है सिस्टर, है ना, उसको भी इम्प्लीकेट कर लिया. वो मैरिड है 10 साल से, उसके बच्चे हैं छोटे स्कूल गोइंग, उसको भी आप इम्प्लीकेट कर रहे हो, जबकि उसका रोल इतना ही था कि वो फ़ोन पे बात करती थी अपनी माँ से, तो वो हर बेटी करती है, लेकिन आप उसको सीरियस ऑफेंस में इन्वॉल्व कर लेते थे. तो तभी ये सब मानवाधिकार अजय शर्मा, अरनेश कुमार, स्टेट ऑफ बिहार, ये गाइडलाइंस देनी पड़ी कोर्ट को कि यार ये इसको रोको, ये मिसयूज़ कर रहे हो आप प्रोविजंस का, ठीक है ना. तो अभी मेरे ख्याल से इन लॉज थोड़े से रिलैक्सड हैं, अभी उनको इतना फियर नहीं रहता कि स्टेट पे पुलिस आएगी और हमें अरेस्ट कर लेगी, ठीक है. तो कोर्ट हैज़ बीन एबल टू डू बैलेंस्ड टू सर्टेन एक्सटेंट, right? So as I said earlier, and we believe in it, that life is a changing process. It's a fast changing phenomena, ठीक है. तो अगर ये फास्ट चेंजिंग है तो चेंजिंग नीड ऑफ द सोसाइटी के साथ में बदलेगा, तो बदलाव ज़रूरी है और आप बदलाव का हिस्सा बनने जा रहे हो. बड़ी बात ये है, यू आर गोइंग टू बी द पार्ट ऑफ इट सूनर और लेटर. मैं ये बोलता हूँ मिनिमम 6 months, मैक्सिमम 1 year. इफ़ यू आर रेडी टू डिवोट, यू वुड बी. It is not a very difficult exam. स्कोप बहुत बड़ा है. All states are conducting these exams. कोई भी स्टेट का एग्ज़ाम छोड़ना नहीं है आपने, ठीक है. एक ही हर्डल है लोकल लॉस, वो आप 1 से 2 महीने में प्रिपेयर कर सकते हो अच्छे से, नोट्स बना के, ठीक है. लेकिन छोड़ना नहीं है एग्ज़ाम. कीप ऑन एक्सपेरिमेंटिंग, कीप ऑन स्ट्राइविंग हार्ड, कीप ऑन अटेम्प्टिंग, एंड द डे विल कम व्हेन यू विल बी थ्रू. फाइन. So my dear online friends, hope you have been watching. Now we'll be taking a break for 1 hour. At 2 p.m. again we reunite and continue with it. Thank you very much for hearing me patiently. I'll keep on giving you insight. Thank you.